The community property question from February of 2010 is one of the most difficult community property questions to appear on the California bar exam. Take a look with me at the call of the question. It indicates that there are 3 items of marital property, and what that tells us is this should not be a racehorse problem. Many times in community property we have 4, 5, even 6 or 7 items of marital property. And those fact patterns really are just a series of short answer problems. But as it turns out, not only does this have merely 3 items, but it has so many issues that it turns out to be something of a racehorse anyway. So this fact pattern really gives us the worst of both possible worlds. Take a look with me carefully at the call. It asks, what are Herb's and Wendy's respective rights and liabilities in 1. The drawing, 2. COINCO, and 3. The hospital bill. Well, we've seen issues identical to those in calls 1 and 2 in many other community property fact patterns over the last 25 years. The hospital bill is a somewhat more novel issue, as it turns out, and it does include a wrinkle of California community property law that you are much more likely to learn by reviewing this question than you would be likely to learn it studying outlines. Now, go with me to the top of the question and let's review the fact pattern briefly. The other thing that makes this question a little unusual is paragraph 1. This couple, Herb and Wendy, are California residents the whole time, so we don't have any quasi-community property issues to deal with. What we do have is a prenuptial agreement, which is described in paragraph 1. And many of us don't really know exactly what prenuptial agreement law is in California, other than, perhaps, generally speaking, California has a fairly liberal view about prenuptial agreements. And as it turns out, the bottom line is pretty much all prenuptial agreements are valid so long as there is no fraud. And there's plenty of fine print beneath that. But as we look at this fact pattern, there isn't a single fact in this pattern to suggest that any fraud or misconduct has taken place. This looks like a prenuptial agreement that is pretty narrow. It restricts as separate property each of the couple's earnings. The husband appears to have been employed the whole time also. There doesn't appear to be any fraudulent intent or any other misconduct or even any unfairness as a result of this agreement. So that's not something you necessarily learn just by reading paragraph 1. It's something you get out of the total body of the fact pattern. But really, the only relevant paragraphs about this agreement are in paragraph 1 and the last paragraph where Wendy wants to uphold the agreement and Herb wants to disallow it. Well, paragraph 1 and paragraph 7 are it for the prenup. It's a pretty straightforward question about California law, and if all you do is guess and say it's probably okay, that's almost certainly good enough. However, the clear answer is, under these facts, it is valid. Paragraph 2, a short paragraph, deals with call of the question number 1. This is a situation that has arisen virtually identically in other fact patterns. Sometimes it's a famous painting, sometimes a sculpture. Here, it's a drawing by a famous artist. And the issue becomes whether or not the fact that it was a quote-unquote gift turns it into the recipient's separate property. And so we've got to get into a little bit of the transmutation law here. But really, call of the question number 1 is quite a simple call, and it's quite a simple issue also. Then we move to paragraph 3. Really, paragraphs 3 and 4 are both going to call of the question 2, COINCO. This is apparently a community property business set up with separate property funds. And the labor being done by Wendy is classically considered community labor. But since her wages are her separate property pursuant to the prenup, this really does become quite complicated. And you see dollar signs in both paragraphs, several different dollar figures, so there's even potentially a little bit of arithmetic to do. So if you are somewhat phobic about numbers, this is not a fact pattern for you. Then in paragraph 5, we learn about their separation, and then in paragraph 6, we learn about call of the question number 3, the hospital bill. And this is yet another wrinkle in this question that makes it more difficult. This is not a run-of-the-mill question about expenses. This is a question about post-separation necessaries. And that's a phrase that you may never have heard before just hearing it right now. And it's, in fact, a real idea from California community property law, and, in fact, it's a tiny little point of law upon which the correct result turns. So, after those 7 paragraphs, we receive the call of the question, and the call, at least, is a classic community property call of the question. There's no doubt about what subject we're in, and there's no doubt about how we're going to organize our answer either. Turn the page and have a look at the outline of issues that I present, and you'll see that what I do to outline the issues presented in this fact pattern is identical to what I do in just about every other community property question that I write a model answer to. What you'll notice, the very first thing you'll notice is the very first thing on this outline doesn't have a Roman numeral. I choose to talk about the prenup first because it seems to me that since that agreement in essence would be part of the governing law when we resolve this marital estate, it's best to deal with it up front. So remember, I think boilerplate at the beginning of a community property answer is a waste of time. However, I always will orient the reader to the facts about the relationship. If it's a California marriage, domiciled in California, and now dissolving in California, I'll indicate that up front and say California community property law will apply. Here, I'll do that, and then I will go on to comment on the prenup. So this answer will have an uncharacteristically long discussion before we get to actually resolving the property interests. Next, we see, with regard to the drawing, I talk about the source, the actions, and then I reach a conclusion that it will be community property based on my consideration of the facts. However, reasonable people can differ, and I can say with certainty that your quote-unquote bottom line answer to question 1 is not going to pass or fail you based on how correct it is. There's room for argument on both sides. Now, COINCO is the most interesting and the most complicated part of this fact pattern. And there are so many different places where reasonable people might differ that, again, I think I can say with real certainty that what matters here is the depth and thoroughness of your analysis rather than the conclusion that you reach. So, I start off by discussing the source of COINCO as being Wendy's separate property. Then I get into the actions. I discuss her wages, the ones that were paid, and their actual value. I will judge her entitled to full compensation for the value of her services. The community gets the value of COINCO itself. So her separate property interest will be in what her wages should have been, not what they were. And I'll talk about the household expenses, and I'll discuss how the value of COINCO fell after the separation. Now, ultimately, we know that the trier of fact here, the judge in family law court, is going to make a decision based on equity. However, the black letter law would be, we'll judge the value of the assets at the time of separation. If facts happen after the separation that require us to make accommodations to the present-day realities, we'll do so. Ultimately, I conclude that the community probably does have an interest in COINCO. However, Wendy will be entitled to ownership and management of the company. It's her labor that really made the company valuable in the first place. And that will wrap it up with regard to COINCO. Finally, we turn to the hospital bill. I talk about how after separation, typically the bills are the responsibility of each separate spouse. However, I will discuss actions that are relevant. My conclusion will be that the bill will be 100% Wendy's obligation. However, if Wendy is unable to meet that obligation, I will find Herb secondarily liable. That's how I apply the liability law as I understand it. So that wraps up a very brief consideration of how the answer is structured. Now let's briefly take a couple of minutes together to consider the model answer that I present. And again, I will suggest a number of respects in which reasonable people might differ. Now, take a look at the first 3 paragraphs of my answer. Actually, the first 4 paragraphs if you count a one-line conclusion. You'll see I lead with the facts. I explain that Herb and Wendy were California residents throughout the time of their marriage, and thus California community property law will apply. But I discuss the prenup, and I go into great depth about it. I explain the law of California prenups in paragraph 2. And in paragraph 3, I discuss the dispute between Herb and Wendy about this prenup in our dissolution proceeding, and ultimately, my analysis reaches the conclusion that Wendy is right and this prenup is going to be valid, and it'll be used to interpret the rest of the dissolution proceedings. Then I turn to the drawing, and here there's plenty of room for reasonable people to conclude opposite to the way that I have done. However, I would suggest that my interpretation of these facts probably is the better interpretation on the whole. I look at the apparent intent of the parties, and I also look to the equity of the situation. This does not look like a hugely affluent couple to me. I think this item of property probably is one of the most valuable things they've got. And again, obviously, the family law judge in the dissolution proceeding has got the authority to resolve a marital estate in whichever way is most just. But my consideration reaches the conclusion that it's almost certainly community property. However, there are those details about the transmutation law, which changed 25 years before this question came out in 1985. Now a writing is required for a transmutation to be effective. We don't know for sure, but many times when a birthday present is given, a card accompanies it. I suggest that that might be good enough to satisfy the writing requirement if one strictly were to be required. Next, I turn to CoinCo. I start off with the inheritance as the source of her investment in this business, but then I go into the actions. And to my way of thinking, this is the heart of this paper, considering Wendy's wages, the prenup, the household expenses, and the fall in value. When you get to my conclusion, I think, again, one might well reach different conclusions if your take on the facts is somewhat different from mine. Also notice that I allude to the possibility of a reverse Van Camp-Pereira analysis. Well, actually, in my answer, I talk about both the standard Van Camp-Pereira and a reverse Van Camp-Pereira, but ultimately, I don't think either formula is very helpful here. Finally, I turn to the hospital bill, and you'll see that I don't spend a great deal of time on this part of the answer. I handle it in 3 short paragraphs. And you might feel like spending a little more time on it, but I just don't think there's a lot more to say about this question. We've got a post-separation hospital bill. Medical care is considered a necessary of life, and although Wendy will be primarily liable for it, if she is unable to pay that bill by herself, then her now or soon-to-be ex-husband Herb will remain secondarily liable. And that's it for a consideration of what I think many of you will agree is a surprisingly unpleasant community property fact pattern.